Hello, everyone, and welcome back. I'm thrilled to have you here as we dive into one of the most talked about and powerful rights granted by the GDPR. Article 17, Right to Erasure, better known as Right to be Forgotten. This is the ultimate reset button for your digital life. So think about that, your digital footprint, every like, every purchase, and every old social media post is all data, and it all stored somewhere by countless organizations. Our trail is vast and often, and it's feel permanent like a tattoo. Or what if that data is old? What if it's no longer accurate? Or what if you simply withdraw your consent? That feeling of unease, that's what the GDPR addresses. Article 17 gives you, the individual, a powerful tool to take back control and decide when your digital past need to be wiped clean. So, what exactly Article 17 is? In simple terms, it's the right to have your personal data deleted by the data controller. That's the company or organization holding the data without undue delay. Now, it's crucial to understand it's not an absolute right. You can't just erase everything for any reason. It applies under specific and defined circumstances. The core idea is if the data is no longer necessary for the purpose it was collected for, you have the right to erase it. So let's visualize this with the data life cycle. First stage is collection. The data is born, you signed up for an account, and the company gather your email and name. The second stage is processing. The data is actively used. They send you service update or process your data. The third stage is storage. They hold on to the data, perhaps in a database. So the fourth stage is erasure. This is where you step in. You evoke Article 17 and the moment is removed. And the data is removed. It's like hitting the physical delete key on that data, making it disappear from their records. This is triggered because you withdraw consent, you objected, or the data is simply no longer needed. So let's look at the six primary scenario where a data controller must comply with your request. Keep these in mind as they form the legal basis for your request. So the purpose is fulfilled. You bought a product, the warranty is over, and they no longer need your shipping address. The necessity is gone. You second is withdraw the consent. You gave a consent for a newsletter, but now you have withdraw it, so there's no legal basis for them to hold your email. So the third one is the objection of processing. So for direct marketing, if you object to them to using your data for direct marketing purpose, they often have to comply. Fourth one is unlawful processing. They collected or use your data without any valid legal basis under GDPR. Fifth is compliance with legal obligation. A separate EU or member state law required the data to be deleted. Data collection from a child. This is about protecting minors. If data was collected from a child using information society service, think social media, the child or guardian can request its deletion. So, the most famous real world example is the Google Spain case from 2014, which truly defined the scope of the right to be forgotten. A Spanish man, Mario Costanza, requested that Google remove link to a 16-year-old newspaper article about a past debt foreclosure. He argued the information was outdated and irrelevant. It was causing him reputational harm. So the European Court of Justice agreed. They ruled that search engines are data controllers and must in certain cases delist search results that are inadequate, irrelevant or excessive. So this did not force the newspaper to delete the original article that would impact freedom of expression. It forced Google to remove the link from its search result. That distinguish is key. It showed the world that outdated digital history does not have to define your present. So that remember that it's not an absolute right. A company can legitimately refuse your request based on an overriding public interest. Here are the main reasons. So, freedom of expression and information. This protect journalists, artists, and publications. They can't delete a legitimate news article just because you don't like it. Second is legal obligation. If they need the data to comply with the law, for example, tax law require them to keep financial transaction record for 7 years. They can't refuse it. So the third one is public interest in public health or scientific research. Certain public interest activities override your right. So fourth one is establishment of legal claims. If the data is necessary for them to defend themselves in a lawsuit, they can keep it. Transition is necessary. So let's conclude this. Article 70 is the important article of the GDPR. It moves us from a world where companies own your data to where you, the individual, have data sovereignty. You have the power to decide when your digital identity deserves a fresh start. Understanding these conditions empower you. It's not just a technical rule, it's a fundamental right in the digital age. If you are a data controller, you must have a clear process to handle these requests. If you are an individual, you know how to exercise your most powerful privacy right. Thank you for joining this lesson. I will see you in the next video.